Two Supreme Court cases happening right now could completely flip the script on your concealed carry rights. And if you don't understand what's at stake before June 2026, you could end up breaking laws you didn't even know existed. I'm not exaggerating. One of these cases could determine whether you can legally carry your firearm into a gas station or grocery store. The other could decide if millions of Americans lose their Second Amendment rights permanently. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could save you from a decade in prison. Hit that button now. This channel covers legal updates that most gun owners never hear about until it's too late. And trust me, you don't want to be the person who learns about these rulings after you've already been arrested. Okay, here's what just happened. The Supreme Court heard oral arguments on January 20th, 2026 in a case called Wolford versus Lopez. Another case, United States versus Hemani, goes to oral arguments in March. Both decisions will drop in June 2026. That's less than 4 months away. And these aren't small technical cases that only lawyers care about. These are massive decisions that will reshape how concealed carry works in America. Let me break down the first case for you. Jason and Allison Wolford live in Hawaii. They have concealed carry permits. But Hawaii passed a law in 2023 that says you cannot bring your gun onto any private property that's open to the public unless the owner puts up a sign giving you permission. So think about that for a second. You walk into a grocery store, no sign saying guns are allowed. Boom, you just committed a misdemeanor. You could get a year in prison. Now, the Wolfords said this is insane. How are we supposed to live our daily lives? Every gas station, every convenience store, every restaurant, every shopping mall. If there's no sign, we're criminals. They sued Hawaii, saying this violates the Second Amendment. The Ninth Circuit Court of Appeals sided with Hawaii. They said, nope, this law is fine. History shows property owners have always controlled who brings guns on their land. The Wolfords took it to the Supreme Court. And in October 2025, the Supreme Court agreed to hear the case. Here's why this matters to you, even if you don't live in Hawaii. 4 other states have similar laws: California, Maryland, New York, and New Jersey. If the Supreme Court says Hawaii's law is constitutional, those states keep their restrictions. And other states might copy them. But if the Supreme Court strikes down Hawaii's law, it sends a message to every state in America. You cannot make it basically impossible for people to carry guns in public by banning them from private businesses unless owners post signs. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Laws vary by state, and what I'm covering here is a general information to help you understand these cases. Don't make legal decisions based solely on a YouTube video. Talk to a lawyer who knows your state's laws. Let me explain what the Supreme Court is actually deciding in the Hawaii case. The court is using something called the Bruen standard. In 2022, the Supreme Court decided a case called New York State Rifle and Pistol Association versus Bruen. That case said, if a state wants to restrict your Second Amendment rights, they have to show that the restriction matches America's historical tradition of gun regulation. In other words, you can't just make up new gun laws. You have to prove similar laws existed back when the Second Amendment was written in 1791, or at least during the 1800s when the 14th Amendment was ratified. So Hawaii is trying to defend its law by pointing to history. They found a 1771 law from New Jersey that said you can't hunt on someone's private land without permission. They also found an 1865 law from Louisiana that said you can't bring guns onto plantations without the owner's consent. Hawaii says, see, history shows we've always required property owner permission for guns. But here's where Hawaii's argument falls apart. The New Jersey law from 1771 was about hunting on undeveloped land. It wasn't about walking into a store that's open to the public. That's a trespass law, not a gun control law. And the Louisiana law from 1865, that was part of the Black Codes. These were racist laws designed to keep guns away from freed slaves after the Civil War. The law wasn't meant to be enforced against white people. It was explicitly created to restrict the civil rights of Black Americans. Here's the crazy part. The Supreme Court justices know this. When the Ninth Circuit upheld Hawaii's law, they relied on these 2 examples. But legal experts are saying there's no way those examples count as a historical tradition. One law was about hunting, not carrying. The other was a racist law that we all agree was unconstitutional. So if those are the best examples Hawaii can find, their law probably doesn't pass the Bruen test. Now, this is where it gets interesting. Hawaii is also arguing something else. They're saying the Second Amendment doesn't even apply here. Their argument is that property owners have always had the right to control who comes on their land. So if a property owner doesn't want guns, they can ban them. And Hawaii is just making that the default. Instead of assuming guns are allowed unless the owner bans them, Hawaii is assuming guns are banned unless the owner allows them. But here's the problem with that argument. The Wolfords aren't arguing about a property owner's right to ban guns. They agree a store owner can kick them out for carrying a gun. What they're saying is Hawaii can't make it a crime to carry a gun when the property owner hasn't said anything. If a store owner is silent, Hawaii is treating that silence as a ban. That's not protecting property rights. That's the government restricting your Second Amendment rights. The Trump administration filed a brief supporting the Wolfords. The Solicitor General wrote that Hawaii's law is designed to thwart the right to publicly carry arms, and laws that effectively negate your Second Amendment rights are unconstitutional, period. The brief also points out that Hawaii's law makes it almost impossible to carry a gun in daily life. You can't run errands. You can't stop for gas. You can't go shopping. Because the moment you step onto private property open to the public without seeing a permission sign, you're committing a crime. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Understanding your rights during police encounters is just as important as knowing the laws. And most gun owners have no idea what to say when they get pulled over. Hit that subscribe button now. All right, let's talk about the second case. United States versus Hemani. This one is even more controversial. Ali Hemani was prosecuted under federal law for possessing a gun while being a habitual drug user. The law says you cannot own a gun if you are an unlawful user of or addicted to any controlled substance. Hemani is challenging that law. He says it's unconstitutional under the Second Amendment. Now, you might be thinking, wait, drug users shouldn't have guns. And I get that. But here's Hemani's argument. He's saying the historical tradition in America was only to disarm people who were currently drunk or high, not people who might drink too much or use drugs when they're not carrying. His point is that if someone is sober and clear-headed, you can't take away their Second Amendment rights just because they sometimes use drugs. This case is way harder to predict than the Hawaii case. Here's why. At the time America was founded, drugs like cocaine and heroin didn't exist, but alcohol was everywhere. People drank a lot back then, like a lot, and there were laws that disarmed people who were drunk. Some laws also disarmed habitual drunkards, the mentally ill, and people considered dangerous to the public. So the question is, does being a habitual drug user today count the same as being a habitual drunkard back then? A group of historians filed a brief in this case. They argue that, yes, it does count. They say the founders knew alcohol could cause lapses in judgment, and they passed laws to keep guns away from people who couldn't control their drinking. The same logic applies to drug users today. Here's what I think is going to happen. I think the Supreme Court will strike down Hawaii's law in the Wolford case. The historical evidence is just too weak. 2 examples from different centuries, one about hunting and one that's openly racist, don't establish a tradition. And the court has been pretty aggressive about protecting Second Amendment rights since the Bruen decision in 2022. But I think the court will uphold the federal law in the Hemani case. The historical tradition of disarming habitual drunkards and dangerous people is way stronger. Multiple states had these laws at the founding. And the purpose of those laws, keeping guns away from people with impaired judgment, matches the purpose of today's law about drug users. Now let me tell you why these cases matter so much. If the Supreme Court strikes down Hawaii's law, it's a huge win for gun owners. It means states can't play games with concealed carry by making private property off limits unless owners post signs. It forces states to respect the default right to carry in public spaces, including businesses. But if the court upholds the drug user law in Hemani, it confirms that the government can still disarm certain categories of people. It's not an unlimited right. The Second Amendment protects law-abiding citizens. But if you're a habitual drug user, you're not in that protected category. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. You need to know about these cases before the decisions drop in June. And I'll be breaking down the rulings the moment they're released. Let me also tell you what's not being decided in these cases. The Supreme Court is not deciding whether states can ban AR-15 style rifles. That issue is still working its way through lower courts. The court is also not deciding whether states can ban large capacity magazines. That's another issue that's pending. And the court is not deciding whether 18 to 20-year-olds have the right to buy handguns. That case is also waiting. But all of those issues are coming. The Supreme Court has basically said, we're going to work through Second Amendment questions one by one. First, we did Heller in 2008, which said you have an individual right to own a gun for self-defense. Then McDonald in 2010, which said that right applies to states. Then Bruen in 2022, which said you have a right to carry in public and set up the history and tradition test. Then Rahimi in 2024, which said you can disarm domestic abusers. Now we're getting Wolford and Hemani in 2026. And after that, we'll get cases about assault weapons bans, magazine limits, and age restrictions. The Supreme Court is building a framework for how the Second Amendment works in modern America. And every single one of these decisions affects you. Here's what you need to do right now. First, if you live in Hawaii, California, Maryland, New York, or New Jersey, pay very close attention to the Wolford decision. If the court strikes down Hawaii's law, your state's similar law might also be unconstitutional. You might suddenly have way more freedom to carry in public, but don't just start carrying everywhere the day the decision drops. Wait for your state to officially change its laws. You don't want to be a test case. Second, if you use marijuana, even if it's legal in your state, understand that federal law still considers you a prohibited person. The Hemani case is about harder drugs, but the same federal law applies to marijuana. If you have a medical marijuana card, you technically cannot own a gun under federal law. I'm not telling you what to do. I'm telling you what the law says. Talk to a lawyer if you're in this situation. Third, understand that these cases are part of a much bigger shift. The Supreme Court is taking the Second Amendment seriously in a way it hasn't before. For decades, the court barely touched gun cases. Now it's hearing them regularly. That's good news if you support gun rights, but it also means the law is changing fast. What was legal last year might not be legal this year. What was illegal last year might be legal now. This information could literally change after June 2026. Subscribe now because the next video explains exactly what you need to do once these decisions are announced. You don't want to miss that. Hit the subscribe button, turn on notifications, because when these rulings drop, you need to know immediately. Let me wrap this up. 2 Supreme Court cases are happening right now that will reshape concealed carry in America. Wolford versus Lopez is about whether states can ban guns on private property open to the public unless owners post permission signs. United States versus Hemani is about whether habitual drug users can own guns. Decisions come in June 2026. My prediction? The court strikes down Hawaii's law but upholds the drug user ban. That means more freedom to carry in public spaces, but continued restrictions on who can own guns. Either way, these decisions will create massive changes in how gun laws work. Here's my final point. The Second Amendment is not unlimited. It never has been. Even the most pro-gun justices on the Supreme Court agree that reasonable regulations are allowed. The question is, what counts as reasonable? And that's what these cases are deciding. History and tradition matter. If a type of gun law existed at the founding and was accepted as constitutional, similar laws today are probably okay. If not, they're probably unconstitutional. Stay informed. Know your rights. Follow these cases. And don't make assumptions about what the law allows. When June hits and these decisions drop, I'll have a full breakdown video ready to go. You'll know exactly what the rulings mean for your state and your carry rights. Remember, this is educational content. I'm not your lawyer. Don't rely on YouTube videos for legal advice. Consult an actual attorney who knows your state's laws and your specific situation. Gun laws are complicated. Getting them wrong can cost you your freedom. Subscribe now, hit the bell, and I'll see you in the next video where we cover what to do during a traffic stop when you're carrying. That's information every gun owner needs. Don't miss it.